no, Raghavan case, no, the Raghavan case, that's right, yes. The Raghavan case has now shown that the, let me just close all the things that shouldn't be here. That the business rescue practitioners who really have full control of the company, and the directors cannot even vote on a business rescue plan of another company which is a debtor of this company. It's all the full management control of the company is in the hands of the business rescue practitioners. There isn't much that the directors can do on their own. They have to act in accordance with the instructions of the practitioner. The practitioner, according to the Act, may remove from office any person who formed part of previous management. What is not clear is, does this mean merely remove from the management or dismiss? I think it's probably merely removing from management, and may appoint a person as part of management or as an advisor, but needs approval by the court if this person has an other relationship with the company. We're not quite sure what this means. It doesn't seem very sensible. So mostly that provision is ignored because nobody really knows what it means. The practitioner, however, does not have the authority to remove from office any directors or to appoint them. The directors may only be removed by an order of court on specified grounds, which all have to do with directors who sabotage the business rescue proceedings. What is not clear is whether the shareholders still have the power to remove a director by ordinary vote, ordinary resolution, as they have under normal circumstances. Or whether the other directors have the power to remove a director as they would have under normal circumstances. That is not clear, so we don't know. It's only when this goes to court, and I don't think any such case has ever gone to court, that we will know how to interpret this. Then the practitioner must appoint inform regulatory authorities and is an officer of the court. There was a Supreme Court of Appeal case where the court said, we don't understand what this officer of the court means. It's actually meaningless. It doesn't really mean anything because he's in a fiduciary, or she is in a fiduciary position anyway. So they have to act ethically. And to say that the practitioner must report to the court, most practitioners are appointed by the board. The court has no role to play there. Who must they report to? How must they report to the court? And it is nonsensical. So that doesn't mean anything. The other new provision is that a business rescue practitioner may not be appointed as the liquidator in a subsequent liquidation, and then probably also vice versa, although that is not stipulated in the Act. You cannot appoint a liquidator as a business rescue practitioner because you wouldn't have the necessary independence that is required. Investigation of the company's affairs, I don't think I need to say much about that. Not financially. Okay, this part is important, but we'll get back to that, where the practitioner must decide immediately after appointment and as an ongoing process whether there is still a reasonable prospect of a company being rescued, and if not, to apply for discontinuation of the business rescue and liquidation. If it's not financially distressed, it must also be terminated. The Act refers to the duty of the practitioner to rectify voidable transactions. Now, when we see voidable, we think of voidable transactions in the Insolvency Act. This is not what this provision means, because a business rescue practitioner does not have the power to have any transactions set aside as voidable. The Insolvency Act does not apply to business rescue. What the drafters probably had in mind was transactions or actions that in terms of the Companies Act are void because they did not follow the required procedure or process or requirements or whatever, then that has to be corrected. But it does not refer to voidable transactions as set out in the Insolvency Act. And then possible criminal acts, I don't think that will be of much use, so we can just ignore that. Then liabilities. The practitioner has the responsibilities, duties, and liabilities of a director. Again, a court said, why didn't they just go to the trouble of setting out the specific duties of a business rescue practitioner? Because they are not directors. They are directors. The company still has its directors. They're still hanging around. A practitioner has very specific responsibilities and duties and liabilities, and they shouldn't have taken a shortcut. I think the court referred to this as a legislative shortcut by just saying, oh, they have the same as the directors. They cannot have the same duties and liabilities of directors because they are not directors. Okay, so they're liable to the company for lost costs and damages. And then it says a practitioner incurs no other liability unless for anything done not in good faith or being grossly negligent. It's not quite clear whether this liability is only to the company or somebody else, but it is probably only to the company. Remuneration. Yes, that is also a delicate subject. In this case of National Union of Mine Workers versus VR Laser Services, the Gauteng Johannesburg court said this case highlights in acute form the need for creditors and other stakeholders to rein in the business rescue practitioners in order to ensure that business rescue is not abused or does not cause considerable harm, or does not result in the business rescue practitioners being the main beneficiaries of the process. In this case, the business rescue practitioners and their attorneys have earned a considerable amount of money from the business rescue process. So that is why really everybody needs to have a very good understanding of the remuneration that business rescue practitioners are entitled to, because some of them have misinterpreted intentionally, I think, misinterpreted the provisions of the Act and paid themselves more than they're supposed to. Okay, so how does the remuneration work? The remuneration of business rescue practitioners is prescribed in section 143, and there are two distinct, different types of remuneration. The first one is their prescribed fees. In terms of a tariff prescribed by the minister, it's in regulation 128, and it's based on the size of the company, not the status or classification of the practitioner. That's the one type of fee. And this fee may not exceed the prescribed tariff. That's an absolute law. Then they are also entitled to expenses and costs. And then in the Murgatroyd case, which is in your textbook, the court said, well, you cannot expect the business rescue practitioner to do everything personally. And especially in complicated cases, you may need, for instance, a forensic accountant or other people, other experts to advise you. And so as long as it's reasonable and there are funds available, a business rescue practitioner may appoint consultants to assist him or her. Then there is the second type of, and then I've already mentioned the SAPOA case to you, where the SAPOA tried to argue that the amounts payable to a landlord post-commencement must also be regarded as costs, and the court made it clear again. Costs here refer to the costs of the business rescue practitioner. Right. Then there's the second type of remuneration. This is an additional or special remuneration that may be agreed on for achievement of specific results. This agreement is between the company, in other words, the board, and the practitioner. But, and this is very important, it is subject to approval by the majority of creditors and the majority of shareholders at meetings called for that purpose. And you'll see in the Absa Bank versus Golden Dividend case, the court said the act is very clear. There must be a meeting. You cannot just insert this special remuneration in the plan and then say, oh, but the creditors approved the plan with my special remuneration in there. So that means my remuneration has been approved. It doesn't work that way. There must be an actual meeting, a meeting of creditors and a meeting of shareholders where they approve this special remuneration that was agreed on between the board and the practitioner. And that's not the end. And this is where you'll see why it is important that there must be a meeting, because even if the remuneration is approved by the required majority, a creditor or shareholder who voted against this approval may apply to court within 10 business days after the voting to have this agreement cancelled because it is not just and equitable, or it is unreasonable having regard to the company's financial situation. So you have to have this meeting. It must be approved by creditors and shareholders, and then those who voted against it still have the right to apply to court to have that agreement cancelled. And business rescue practitioners who have been claiming huge amounts of fees have tried to circumvent this, and they are not allowed to. If they are paid a special remuneration without all these requirements having been met, it is invalid and they are supposed to repay it. Okay. Then, let me see. The Diener case, let me see, where do we have it here somewhere, or in your notes perhaps? I see it is. Anyway, let me explain the Diener case to you. I'm sure it's mentioned somewhere. Because in the case of Mr. Diener, he was the business rescue practitioner, but the business rescue was not successful. The company was placed in liquidation, but there were still some fees payable to Mr. Diener. Then when the company was in liquidation, it turned out the company only had one asset, and that was secured for basically the full amount of its value to a secured pre-commencement creditor. So Mr. Diener argued that his fees should enjoy the same preference as the liquidator's fees and costs, because, as you may know, in a liquidation or in insolvency, if there are no other assets available, the insolvency practitioner or the liquidator can be paid from the proceeds of the secured asset, and then whatever remains will then be paid to the secured creditor. And if that is just enough to pay the secured creditor, there is no free residue left. So Mr. Diener argued that his claim for his fees, his unpaid fees as business rescue practitioner, should enjoy the same preference as the liquidator's costs and fees, because he is given a special preference in the act. The court did not agree. It went up all the way to the Constitutional Court, and the court said there is nothing in the act to say that you have a super preference. The Insolvency Act is very clear about the preferences, and very clear about the fact that, and our common law is very clear about the fact that a secured creditor has the right to be paid from the proceeds of the secured asset, and only if there's something left can other costs or fees be paid. But you are not ranked equally with the liquidator. You are a concurrent creditor like any other creditor. you don't have any special security. You have a preference, so you can be paid first if there's a free residue. But in this case, there was no free residue, and you cannot be paid from the proceeds of the secured asset, because only the liquidator is entitled to be paid from that. You have to fall in line. And in this case, Mr. Diener was so convinced that he has the super preferent claim that he didn't even prove a claim in the liquidation. And the court said, you are a concurrent creditor, and like any other concurrent creditor, you have to prove your claim. You cannot just be paid. And unfortunately, in this case, apart from the fact that you didn't prove a claim in the liquidation, there is also no free residue left, and so you will get paid nothing. Okay. Then, study unit 7, a very important part of the business rescue is the fact that the business rescue practitioner must draft a business rescue plan. This was not a requirement in judicial management, and it was regarded as one of the weaknesses of judicial management. The Act says the practitioner must prepare this plan after consultation with the management of the company, creditors, and affected persons. And there is actually a case where I think it was a creditor, or I'm not sure now, but anyway, or maybe because it was an employee who obtained an interdict against the meeting to approve the plan, because he said there had not been enough consultation with all the affected persons. And the court actually granted this interdict. I think the court was wrong, because I don't think this duty to consult with the management of the company, etc. I don't think it's such an absolute duty. It's just a general requirement. You must talk to them. You cannot come up with a plan without at least talking to the people who know the company. And then there's also a requirement that the plan must disclose if there was an informal proposal by a creditor in this plan. Now, on the one hand, saying you must consult with creditors, and then the other hand, and if there was an informal proposal by a creditor that you included in the plan, you must disclose that. Obviously, if you talk to creditors, there will be informal proposals, so I don't know why specifically you have to disclose that. But anyway, the drafters maybe had something in mind. Prescribed contents, I won't even go there with you. Lots of requirements, many of them unnecessary, some of them not even applicable in all cases. So it's difficult to see why all these requirements had to be set out. Actually, it would have been quite enough to simply stop with the introduction and to say it must contain all the information required to assist affected persons to decide whether to accept or reject the plan. That's it. That's all you need. But to have a whole list of sometimes completely irrelevant provisions that must be included makes this a very expensive and difficult process, and it's really not necessary. Because the more complicated the case is, obviously the more detail you will have in your plan. But if it's a very straightforward, a small one, why bother with all this detail? Apart from the fact, as I've said, that some of these requirements don't even apply. Apart from that, in the Beginsel case, the court said, obviously, not all the prescribed contents will apply, so substantial compliance will be enough. Basically, as I said, that first paragraph, as long as you have all the information that these people require to decide must they vote for or against the plan, that's all you need. So all these other requirements are not necessarily need not necessarily be there. However, we have this long list of requirements, some of which are not always applicable. Substantial compliance is sufficient, but in any case, there is no sanction for non-compliance. If your plan does not comply with the prescribed contents, so what? If the creditors are prepared to vote in favor of it, There's no problem. There's no sanction if your plan does not comply with the requirements. So it's as one court said, it's a bit nonsensical to to have prescribed procedures or contents, but if you don't comply with that, it doesn't matter. It means nothing. Okay. So there's also no remedy for affected persons. What do you do if the plan doesn't comply? You can vote against the plan, but if the majority of creditors vote in favor of the plan, then your hands are tied, because then you are bound to this plan, whether you voted for or against it. Publication of the plan, again, the plan must be published within 25 business days after appointment of the business rescue practitioner, but you can ask for an extension by the court or the majority in value of creditor. It's not clear whether this must happen at a meeting, but it's probably not necessary. It's also not clear whether only independent creditors must give you this extension. But again, well, firstly, the 25 days are a little bit too short. The period is too short for a complicated business rescue. So in most cases, the business rescue practitioners have to ask for an extension. You have to publish it to the affected persons. There's again in the regulations a whole list of requirements of how this plan must be published. But again, if you do not publish this plan within 25 business days and you haven't asked for an extension, there's no sanction. The Act doesn't say then what now happens if you haven't done so. Now, you can perhaps, as an affected person, apply to court for the business rescue to be terminated because there's no prospect of a rescue, because without a plan there cannot be a rescue, but that could take time and it will cost you. In one case, the DH Brothers case, the court said if there's no plan within 25 days, no extension granted, the business rescue proceedings terminate. Unfortunately, as was pointed out in the Shoprite Checkers case, there is no such provision in the Act. It doesn't terminate just because no plan was published within the prescribed period. So, in fact, there is no real sanction except that you can apply and hope that the court will grant you this order because no plan has been published. Right, now, the important thing is this plan must be approved. So the Act states that within 10 business days after publication of the plan, a meeting of creditors must be convened to consider this proposed rescue plan. Now, this is quite important. A subordinated concurrent creditor must be notified in writing by the practitioner that within at least 15 days before the meeting that you are a subordinated creditor, you have been classified as such, and that means you only have a vote equal to the claim you would have in liquidation, which, as I've said, would be mostly zero. But you may apply to court for a review of this. Now, again, remember that you are not subordinated. Not all concurrent creditors are subordinated. Only creditors who have contractually agreed to be subordinated. Those are usually the directors, for instance, or the people who started the company on loan and they have loan accounts. They would say, well, in a liquidation, we agreed to be subordinated so that we won't be paid before other creditors have been paid in full, or they've been paid at least 50 cents in the rand or whatever. But otherwise, you are not a subordinated creditor. And that means you have a claim or a vote based on the full amount of your claim. It's only subordinated concurrent creditors who have a vote based on the liquidation value of their claim. And why I say that's important is because there was case, one of the very big business rescue cases where the business rescue practitioners, senior, experienced, whatever, highest class of business rescue practitioners, who should and probably did know better, informed all concurrent creditors that they only have a vote on their business rescue plan based on the liquidation value of their claims, which is nonsense. That's not true. You have a vote for your full claim unless you have agreed to be a subordinated creditor. Also, as far as I know, the creditors were not informed before the time that they've been classified as subordinated, which is also in contravention of the Act, because you must be given time to apply to court if you don't agree with this classification. Then, the notice of the meeting, at least 5 business days before the meeting, must go to all affected persons, although not all affected persons can vote on this plan. So the date, time, and place of the meeting must be given, the agenda, and then the notice must specifically say who has the right to vote and who is not allowed to vote. And if you don't have the vote, I don't think you're allowed to participate. So you can't even attend a meeting, but you have to be informed about this meeting. Right. So, voting on the plan. First of all, the Act specifically states that the representatives of the employees must be given an opportunity to address the meeting. So the trade union or the unregistered trade union must be given an opportunity to address the meeting to persuade the people who do have a vote, which would be the creditors, whether to vote for or against the plan. Amendments to the plan, or if the plan is rejected, development of a new plan may be proposed by a creditor and voted on by creditors. Now, here you'll see that basically only creditors have a vote. But remember, employees can also be creditors if the company owes their money from before commencement of business rescue. If the plan is supported by more than 75% in value of all the creditors who voted, and at least 50% in value of the independent creditors who voted, and no rights of any shareholders are altered, the plan is regarded as finally approved. So shareholders can only vote if their rights will be altered. If their rights will be altered, the plan must also be approved by a majority of the relevant shareholders at a meeting that must be held immediately. Now, what would be the situation if or under what circumstances would the shareholders have the right to vote? The one situation that we know of is, you will see when the power of the implementation of the plan is discussed in the Act. It states that the business rescue practitioner may issue authorized shares if that's necessary to implement the plan. However, if the business rescue practitioner has to issue unauthorized shares, in other words, the memorandum of incorporation of the company does not provide for the issue of those shares, in that case, the business rescue plan must be approved by shareholders. So in other words, because the shareholders' rights will be diluted in that more shares will be authorized and issued, in that case, that is one case that we know of that the Act regards as rights being altered, and then the shareholders have the right to vote on the plan. Okay, now, what is the effect of approval of the rescue plan? If the plan is approved by the necessary majority of creditors, and if relevant, the shareholders, The plan is binding on the company and each creditor. And you will see in the Act that it specifically states that this plan will, if approved, will be binding on every creditor, irrespective of whether that creditor was present at the meeting or voted in favor of adoption of the plan or had proven their claims against the company. Now, that's a bit weird to talk about that because nowhere in the Act, in Chapter 6, does the Act require creditors to prove their claims. So I don't know why that was inserted, but in any case, every creditor is bound, even a creditor who didn't know that the company was in business rescue. Then the other thing is that the Act does not provide for the amendment or setting aside of a plan that has been approved. If you have to amend your plan, you will have to call a meeting of creditors again and get them to vote in favor of amendment of the plan and then vote in favor of your amended plan. And there is now it's been held before in previous cases, but now we have a very recent Supreme Court of Appeal decision where the court very clearly states you cannot amend a plan that has been approved. And even if your plan provided for a unilateral amendment by business rescue practitioners, should it be necessary, that is absolutely not valid. You cannot, as business rescue practitioners, you cannot unilaterally amend the plan. You have to go back to the creditors and have them approve the amendment. Otherwise, it's invalid. Then there is section 154.1 that talks about the discharge of debts by creditors who exceeded. Even the courts have said that the Supreme Court of Appeal actually said they don't know what exceeded means, what sort of action would be required, must it be in writing, must each individual creditor agree, what does it mean? So on that point, we're not sure. However, you will see that section 154.2 provides that yes, 154.2 is the one that states that you cannot, a creditor cannot enforce a claim against the company unless, and we're talking about pre-commencement claims here, unless it is in terms of an approved business rescue plan. So that means once the plan has been approved, a creditor cannot claim more from the company. You can only claim what you're entitled to in terms of the plan. So you cannot enforce the rest of your debt. Now, the question then was, what about sureties? Because in terms of our common law, a surety is not liable if the main debt no longer exists, because a surety is accessorial in nature. In other words, it is accessorial to the main debt. If the main debt falls away or is discharged, then the suretyship also falls away. So the courts couldn't quite agree on what the effect will be of an approved business rescue plan on sureties. And there were fairly strong conflicting judgments on that. You'll see on page 320, the last paragraph of part 12.7.4, the effects of approval, where it states, the effect of an adopted business rescue plan on sureties remains uncertain because it's not addressed in the Act. Well, the Supreme Court of Appeal has now addressed this matter in the case of Van Zyl versus Auto Commodities Pty Limited. And what the Supreme Court of Appeal held in this case, the court said the main debt does not cease to exist after approval of the plan. Section 154.2 merely provides that the debt cannot be enforced against the company except in accordance with the plan. But the debt still exists, which means that the suretyship still exists because the debt has not disappeared. And so the surety can still be held liable by the creditor for payment of the debt, or at least the unpaid part of the debt, because that debt still exists. It has not been discharged. It hasn't disappeared. So the creditor can claim the balance of the claim. Yes, can claim the balance of his claim or his debt from the business rescue, from the company. No, not from the company. The creditor can claim that amount from the unpaid amount from the surety. I'm just looking for the judgment here where the court said approval and implementation of a business rescue plan does not release a surety from liability to a creditor for payment of the unpaid part of the creditor's claim against the company in business rescue. The debt still exists, but may only be enforced to a limited extent. The rights of a creditor under a deed of suretyship constitutes property within the meaning of Section 25(1) of the Constitution, and so you cannot deprive that surety, or rather that creditor, of his right to enforce payment against the surety. So the surety will remain liable, which at least is one uncertainty that has now been removed. Right. If the business rescue practitioner must oversee implementation of the plan by the company, and then the authority to issue shares, authorized shares, the business rescue practitioner may issue. Unauthorized shares can only be issued if the plan has been approved by the shareholders as well. So that's an important one. And then once the plan has been substantially implemented, the business rescue practitioner must file a notice of substantial implementation, because otherwise the CIPC will not know that you have that the business rescue is over. But then once that notice is filed, then the business rescue will end. The CIPC has also issued a practice note on that. I think it's number 3 of 2021, where it states exactly what you should file for the different notices that you must file to indicate that business rescue has terminated. So that's important, that you must file that notice and the business rescue will then end. However, what happens if the plan is rejected? What is the effect of that? Now, the practitioner or the creditors may propose, if the plan is rejected by the majority of the creditors, then at that meeting, the practitioner or creditors may propose that a revised plan must be drafted by the practitioner, and the practitioner must then prepare and publish such a revised plan within 10 business days. Alternatively, the practitioner may apply to court, or if he or she doesn't do that, then an affected person a person present at the meeting, so that would be basically a creditor, may apply to court to set aside opposing votes as inappropriate within 5 business days. Now, first of all, you can only use it to have votes against the plan set aside. You cannot apply for votes supporting the plan to be set aside. So it's only opposing votes or votes rejecting the plan that you can apply to court to have set aside as inappropriate. The Act says you must then, the practitioner must then postpone the meeting until this application has been heard by the court. In the KJ Foods case, which you will find in your notes, if not in, yeah, it's not in the textbook, in your notes, the court said if the court grants this order, that votes are set aside, there's no need for a new meeting, because obviously then you now know the plan has now been approved, because the votes that rejected the plan have been set aside, they don't count anymore. So now you have a majority of creditors who voted in favor of the plan. So there's no reason to have another meeting. The plan has now been approved and can be implemented. The question now is, how do you test for inappropriateness? In other words, how do you decide? How does a court decide that a vote against the plan is inappropriate? Now, you may remember right at the beginning when we talked about major creditors who indicate right at the beginning when an application for business rescue is made, when they say we won't vote in favor of any plan because we don't believe in this process or this business rescue. And that the Supreme Court of Appeal in Oakton said you can't ignore that as long as it's reasonable. You cannot, and in the other case, you cannot ignore a creditor who reasonably will vote against a plan because it's in his own best interests. Well, the courts, not everybody agreed on that test. In Advanced Technologies, the court was again very outspoken and said, how can you say to a creditor, your vote is inappropriate? As long as that creditor votes reasonably and bona fide to protect his or her own interest, you cannot tell them that it is inappropriate. Unfortunately, however, there were other cases where including KJ Foods, which was also a Supreme Court of Appeal case, just like the Oakton case, but in the KJ Foods case, the court said you cannot vote against a plan just because it is in your own personal best interests. You cannot subjectively decide to vote against a plan because it's in your own best interests. You must take into consideration the interests of all the affected persons, including and especially the employees. And if they are going to lose their jobs because you rejected the plan, then your vote is inappropriate. So basically, the KJ Foods case said, also the Supreme Court of Appeal, that a vote that you vote against the plan because you subjectively, although reasonably believe it is not in your own best interest, that is inappropriate. You must take into consideration the interests of all affected persons. Basically, similar to something like the advantage to creditors in sequestration of an individual's estate. Now, considering the fact that creditors have no say in the commencement of business rescue, where it is commenced with a filing of a director's or board resolution, they have no say in the process. Their only protection really is to vote against a plan if the plan is really inappropriate. But now they're being told they cannot protect their interests, although it's the only way for them to protect their interests. Now they are told, no, you cannot protect your interests. You cannot just take your own interest into consideration. You have to think of all affected persons and their interests, and you cannot vote against the plan if by just selfishly taking your own personal interest into consideration. And I'm afraid that now seems to be the settled law, because in that case of Ferrostaal versus Transnet, again, in this case, Ferrostaal actually applied for the vote of Transnet to be set aside, the vote of Transnet to be set aside, where Transnet voted against a rescue plan of a subsidiary of Ferrostaal. And Ferrostaal said this is inappropriate and it should be set aside. In this case, the court confirmed that it is an objective test to decide whether it's inappropriate or not. But in this case, the court actually decided that it was not inappropriate, in particular because there were no employees involved. The company in business rescue also did not have a real business. Its only business was its rental income from a property it leased from Transnet in the port. So the court said, well, there are no employees who can be harmed or will lose their jobs. There's no real business going on here. And also the plan is quite unreasonable towards Transnet, because they are then expected to just write off millions of rands that are already owed to them. And they must just take their luck. They must continue to have this, to rent out this property to the business, the company in business rescue, and just hope for the best that they will actually be paid for that. So in this case, the court said no, it was not inappropriate, but the principle was confirmed that the court will not only look at the personal interests of the creditor who voted against the plan, but take into consideration the interests of all affected persons, including and in particular employees. If there are employees who will be losing their jobs, then the court will be less inclined to refuse the application and will be more inclined to set aside the vote against the plan. Okay, then there's a third option, which is the binding offer to acquire votes. Now, it wasn't clear, it still isn't clear what the drafters meant by the binding offer of a creditor to acquire the votes of a person who voted against the plan. The binding part of that provision was not clear. Who is bound? Is it only the creditor who offers to buy the votes of a person who voted against the plan, or are they both bound the moment this offer is made? And in the High Court, it was actually originally held in that Kariba furniture case that they are both bound. So if the creditor comes to you after you have voted against the plan and say to you, I am making you a binding offer based on the liquidation value of your claim, and you can't refuse because you are now bound, and the Supreme Court of Appeal said, no, that's not correct. In our law, a binding offer merely means that the person making the offer is bound and cannot retract that offer. So once you've made the offer, then it is up to the other person to decide, will they sell their votes to you or not? So that is your last opportunity. Once you have made a binding offer, there was a recent case, again, I'm not going to mention this one to you because it's very, very recent, and it's a little bit complicated. You won't get that sort of situation very often, where a creditor made a binding offer to other creditors and they refused the offer. So this creditor said, well, in terms of the Act, the business rescue practitioner is supposed to have a meeting again after the binding offer has been made and considered, and then to vote again. And then this creditor whose offer was refused said, and then I can use one of my other options. If I vote against the plan again, I can use one of the other options, such as, for instance, applying to court for the votes to be set aside, or maybe to propose a revised plan. The practitioner said no. Once the binding offer has been refused, that means the majority vote was for rejection of the plan. That's the end. The plan has now been rejected, and I must now act accordingly, as set out in the Act in section 153, what I must do if the plan is rejected. This went up to the court, to the High Court, and the court said the business rescue practitioner was correct. You cannot insist on a meeting. There's no sense in having a meeting. The meeting must only be held if the binding offer is accepted, because now the votes have changed, the numbers of the votes. Now you must have a meeting again so that you can count the votes again to see if the majority is now in favor of approval of the plan. So obviously then things have changed, and the plan could actually be approved. But if the binding offer is refused, that's the end of it. The business rescue terminates right here. Now, the other thing is that if you look at section 153(5), it says, if no person takes any action contemplated in subsection 1, in other words, all these plans you can have, if the plan is rejected, like a proposal for a revised plan or setting aside the votes, etc. If nobody does anything, either the practitioner or an affected person, the practitioner must promptly file a notice of the termination of the business rescue proceedings. So from that subsection, it looks as though the rescue will terminate when the practitioner files the notice of termination. However, when you look at section 132, which deals very specifically in section 132.2, deals with the termination of business rescue proceedings, and there you will see that the subsection, let me see, in C, subsection C1, if a business rescue plan has been proposed and rejected, and no affected person has acted to extend the proceedings in any manner contemplated in section 153, that's when the business proceedings end. So this subsection does not require the filing of a notice to end it. According to section 132.2, the business rescue automatically ends the moment the plan is rejected and nobody does anything about it. And then in the Land and Agricultural Development Bank, KwaZulu-Natal case of 2021, the court said we must follow, these are two clearly conflicting provisions. The one says you must file a notice to end it. The other one doesn't talk about a notice. We must go with section 132.2 because that's a section that very specifically deals with termination of business rescue. And in terms of section 132, the business rescue will automatically end if the plan is rejected and no further action is taken. Right, now, study unit 9. We are very close to the end, you'll be happy to know. The drafters of chapter 6 for some reason believed that you can complete a full business rescue procedure within 3 months. That's hardly ever achieved, even in fairly simple, straightforward business rescues. It usually takes about 6 months, and of course, as you've seen with South African Airways, it can take years. So section 132.3 provides that if the proceedings have not ended 3 months after commencement of business rescue or a longer period allowed by the court. So the business rescue practitioner can apply to court for a longer period. If it hasn't ended, the practitioner must provide a monthly progress report to each affected person and to the CIPC. The court doesn't know what to do with such a report, but the CIPC will watch you. If you are a business rescue practitioner, you have not been granted a longer period by the court, you have to provide a monthly progress report to each affected person and to the CIPC at the end of every month. And initially, the CIPC was very relaxed about this. So they didn't check whether you filed the report. And if you did and you just said there's no progress, that's fine. That's a report. Not anymore. They want to know exactly what has happened since the previous report. What have you done to make this procedure progress? What are the problems? What have you done about them? And they will watch you, and they can, this is one of the grounds on which they can and will suspend your license if you do not file as a business rescue practitioner your monthly progress reports at the end of every month after this 3 months period, because they want to know what is happening. Because some business rescue practitioners, their only contribution to the procedure is to collect their fees every month, and apart from that, they do nothing. Right. And so there's a specific form that must be filed for this notice, and you must explain exactly what is going on and what your progress has been. Right, then the last part is the termination of business rescue proceedings. They are terminated in two ways, either by the court or a filing of a notice with the CIPC. So the business rescue is terminated by a court order if the court sets aside the resolution, or in some cases, even if there was an application for the practitioner's appointment to be set aside. So that's the Section 130 procedure. Also, if the proceedings are discontinued and the company is placed into liquidation. Now, the Section 141(2) places an obligation on a business rescue practitioner that should the practitioner at any stage in the business rescue come to the conclusion that there is no longer a reasonable prospect of a rescue of this company or close corporation, the practitioner must apply to court to discontinue the proceedings and to place the company into liquidation. The Act talks about conversion, but it's not really a conversion, because the Act is very clear that you must discontinue the proceedings and place the company into liquidation, and that's by order of court, and there is a duty on the business rescue practitioner to do this if at any time he or she comes to the conclusion that there is no reasonable prospect of a rescue. And then if at some stage the practitioner comes to the conclusion that this business rescue, this company is no longer in financial distress, if the business rescue was commenced by way of a court order, you have to apply to court to terminate the business rescue by court order. You cannot just terminate it by filing a notice or something like that. As far as filing a notice with the CIPC is concerned, that first one, where the plan has been rejected and no further action is taken. Now, the court said in that agri case that I've just mentioned that the filing of the notice is really an administrative action to inform the CIPC that the plan was rejected and no further action was taken, and therefore the business rescue proceedings have terminated. It's not a requirement for termination. It's just so that the CIPC will know. Otherwise, they will, as far as they are concerned, the company is still in business rescue. So it's really just administrative to inform the CIPC that the business rescue is over. Also, if there has been substantial implementation of an adopted plan, there you have to file a notice of substantial implementation to terminate the business rescue. So that is an absolute requirement for termination. And by the way, the Act does not define substantial implementation, so you have to stipulate that in your plan. At what stage will it be regarded as being substantially terminated? And then thirdly, if it was commenced by a board resolution and the practitioner finds that the company is no longer in financial distress, he or she can file a notice with the CIPC, and that will be the end of the business rescue. That is also the end of the part on business rescue proceedings. So all that remains for me is to quickly talk to you about the compromise between a company and its creditors in terms of Section 155. This procedure is actually not used often enough. The Section 311 of the 1973 Act, which also provided for a compromise between a company and creditors, was very often used, although it was a far more complicated process than the Section 155 one. 155, however, only deals with a compromise with creditors, not an arrangement with shareholders that you find in Section 114 of the Act. It's another option for companies in trouble, but it's not an absolute requirement that the company must be in financial distress. And it involves an agreement with creditors or a certain class of creditors that they will accept a smaller payment, or they will wait for a longer period to be paid. Now, the board of a company, or if the company is in liquidation, the liquidator may propose a compromise of its financial obligations to all its creditors or any class of creditors. The disadvantage is there's no moratorium during the negotiations, but if the company is in liquidation, it's protected in any case against the claims of creditors. So it is a fantastic way and a cheap way to have the same results as for a business rescue, but much faster and much cheaper and much simpler. Now you'll see in the Act, the requirements for the proposal are basically just a copy and paste of the requirements for a business rescue plan, which is nonsense because a compromise is supposed to be a much more informal procedure where you can adapt your proposal to the situation. So, and the court doesn't have to approve this. So, I would think that you can basically ignore all these requirements. All you need is to put in all the information reasonably required to assist creditors in deciding whether to accept or reject it. Only put in the information that is necessary for them to decide. If this proposal is adopted because it is supported by a majority in number, representing at least 75% in value of the creditors or class of creditors present and voting at the meeting, then the Act says may, but you will see that they actually must apply to court for approval of the adopted proposal. The court may sanction this compromise if it's considered just and equitable, having regard to the number of creditors present and voting in favor of the proposal, and if the company is in liquidation, also the report of the master. A copy of the court order must be filed with the CIPC within 5 business days and attached to each copy of the MOI. Now, here's the catch. A sanctioned compromise is final and binding on all the relevant creditors as of the date of filing. So this seems to indicate that if you don't get the court to sanction your compromise, only creditors who voted in favor of the compromise will be bound. So you need the sanctioned compromise so that all creditors, or at least all creditors of that particular class, will be bound by this compromise. Now, the important thing also is that if a company is in liquidation and the liquidator makes an offer of a compromise to the creditors or a class of creditors, and they accept it, if this compromise is accepted, the compromise may contain a condition stating that if this compromise is accepted, the company will be allowed to apply for the setting aside of the liquidation order, and these creditors will not oppose it. In that case, the company can, without having to appoint a business rescue practitioner, without having to go through the whole process of applying for a business rescue order, can simply achieve the very same results as in a business rescue. The liquidator gets his usual fee, so you don't have the costs of a business rescue practitioner, and you can get exactly the same end result because once they have the creditors have accepted the compromise, then probably your company will no longer be in financial distress because it will be able to pay its debts as they become due. So it will not qualify for business rescue. And then in a much faster and quicker and cheaper way, you can, as a company, be rescued from liquidation by using the compromise procedure. And unfortunately, that is not used nearly often enough. I think because many practitioners are not, and I mean legal practitioners, are not aware of the benefits of using the compromise to achieve a rescue of the company. And that's why I said right at the beginning that even liquidation, apart from other situations where you can also use liquidation to rescue a company, you can actually rescue a company or a closed corporation by using Section 155. And that, ladies and gentlemen, is the end of my very long uh, talk. I hope it helps a little bit. If you have questions, you are welcome to email them to Mrs. Libber. She will forward them to me, and I will try to answer them as far as possible. Thank you very much.